Dear Frederika, thank you for being with us. Currently, it is our 5th day of Ukrainian International Criminal Justice Week, and today we speak about important and relevant topic for present-day modern Ukraine, a country that fighting illegal Russian military invasion, aggressive war of Russia with Ukrainian people. And our speaker today is Ms. Frederika Schweighoferova, international lawyer, expert of human rights, director of Rome Statute campaign of international NGO, Parliamentarians for Global Actions. And today she will stay with us for 1 hour to discuss important topics of state cooperation with International Criminal Court, how it's done and how to do it effectively. Frederika, thank you, and the floor is yours.
Thank you very much, and thank you for organizing this very important week as every year. So for those that may not be familiar with PGA Parliamentarians for Global Action mandate, I'll just very briefly mention that we are a network of parliamentarians worldwide that join us in their individual capacity because of their commitment to the rule of law, human rights, gender equality. Currently, we have around 1,200, so 1,200 parliamentarians from 130 countries, including regional parliaments. We've been working with our Ukrainian members on the enhancement of certain legislations to fight the impunity and to enhance the accountability for the atrocities that have been committed on the territory of Ukraine since 2014. And of course, in the last months, we have been intensifying our efforts with our members to promote accountability. So in my presentation, I will focus on the cooperation, but I will also look at it a little bit from a broader perspective, because it's not only the cooperation law itself, which is the requirement for the efficient cooperation with the ICC. Actually, the successful cooperation with the ICC that we see now, how important it is in light of the current events, is derived from 3 legislations. So one is on the law on the ratification. Now, in the context of Ukraine, this is somewhat substituted by the 2 ad hoc declarations through which Ukraine has effectively accepted the jurisdiction of the ICC. Of course, I will have to mention that for the perspective of Ukraine, it would be much more beneficial if it actually ratified the Rome Statute, because it would have a position, a voice in the decision-making powers at the ICC. It would be a part of the Assembly of States Parties. So even though its obligation to cooperate and its jurisdictional regime would be the same, it would be much more beneficial for Ukraine if it actually ratified. And of course, this is also in line with the Article 8 of the EU-Ukraine Association Agreement, where Ukraine specifically committed to the ratification of the Rome Statute. And also important to mention that as a state party to the ICC, it would have actually a power to make any amendments to the Rome Statute. And again, now we see how important this would be in the context of the crime of aggression, where the ICC has a very limited jurisdiction. So I cannot emphasize enough how, even though the current 2 ad hoc declarations may be sufficient for the perspective, from the perspective of the cooperation with the ICC, for Ukraine, it is not as satisfactory as it could be. The second element, which is a legal element, which is required for effective cooperation with the ICC, is the complementarity law. So this is the law that harmonizes domestic law with international legal standards, so international criminal law, ICL, and international humanitarian law, IHL. And in addition to crimes, it also includes some principles under international criminal law. And in terms of the complementarity law, it's very important to know that the way how the ICC operates, it's through this principle of complementarity. So it means that the primary responsibility to conduct any investigations or prosecutions lies with Ukraine. The ICC only steps in if Ukraine is not able or it's not willing to genuinely conduct these proceedings. So the ICC only complements the domestic system, and this creates a synergy with the domestic accountability system through reinforced cooperation. So the most important provision is enabling a state to conduct these proceedings domestically, which means that to incorporate the Rome Statute crimes and principles in domestic law. And of course, it's not only Rome Statute system crimes. This is part of customary international law. These are Geneva Conventions, which Ukraine has ratified. So they have just been codified through the Rome Statute. Such comprehensive implementing legislation has already been adopted by the parliament in Ukraine last May through law 2689. And the law was called on amendments to certain legislative acts on the enforcement of international criminal and humanitarian law. However, as unfortunately we are all aware, this law has never been promulgated. So effectively, Ukraine doesn't have this implementing legislation. But just to mention that this law was a very solid law. Well, it was also authored by experts, by parliamentarians, and also we were included in the process of drafting of the law. And it included it entailed crimes against humanity, which are currently missing in the criminal code of Ukraine. It complemented the jurisdiction over war crimes because also they're only partially implemented in the domestic law of Ukraine. And then also the law included provisions of ICL, of international criminal law, which are very important, and including command responsibility that I will just touch upon in a second, but also it ensured that there are no limitation periods under national laws that would prevent a person from being prosecuted. And this is very important because for international crimes, there is no statute of limitations. So they can be tried even after 50 years after their commission, which is not the case for ordinary crimes. So the thing is that the law has never been promulgated, and then there has been recently a new law which was drafted, which would replace this 2689, and this new law 7290 includes the crimes, but it removes some of the provisions that we considered highly important for effective cooperation with the ICC, even though they are of substance or more substantive nature. And I'll go into a little bit more details on all four, or at least the three that we identified. So this would be, first of all, that the new law only partially implements the principle of command responsibility. So basically, this is a principle under which a commander is responsible for the conduct of its subordinates and has to oversee. Basically, it's responsible because the responsibility of the commander is to oversee the conduct of the troops. So the commander can be held accountable for failing to prevent commission of crimes by the subordinates. And under this, it's a principle of IHL. It was included in Additional Protocol 1 to the Geneva Conventions, Article 87, which Ukraine ratified in 1990. And so it's an established principle according to which the commander is responsible and can be held to account if he knew or, owing to the circumstances, should have known that the troops are committing the crimes. And I understood that this has been to some degree conflated with the current existing provision under the Ukraine criminal code of willful failure to prevent a crime committed by subordinate. And this is in Article 426 of the Criminal Code of Ukraine. However, we see the difference because under that provision, it's the willful failure to prevent the crime, whereas the common responsibility principle also criminalizes if there is no intent of the commander to fail to prevent the crimes, but in their position, they should be aware of the crimes being committed. And of course, this is, the principle stems from the fact that there is a chain of command in any armed forces or groups. There is someone that has to be responsible for the troops. There has to be some kind of system. So if the subordinates carry out any unlawful acts, the commander has to make sure they are aware, so the commander is aware, and then tries to prevent or punish or report the crimes. And now what happened in the context of the new legislation of Ukraine is that it still includes the common responsibility, but remove the should have known doctrine. So this was the easiest defense for any commander, saying, I didn't know. So the moment that there is no evidence that the commander actually had been informed, which, often there is no evidence. So the moment there will be none, it will be the easiest defense for the commander to escape any accountability. So it is for this reason why the provision is of particular importance, and why it's relevant for the cooperation with the ICC is that basically not having the should have known doctrine under the common the common responsibility principle means that there would be a diversity of actors that would not fall under the Ukrainian domestic system of jurisdiction. So the ICC would have to step in. So again, it would hamper the synergy and the cooperation between Ukraine and the ICC. Second provision that we identified that is missing under the new law is universal jurisdiction. And universal jurisdiction would enable Ukraine to try any perpetrator without any link to Ukraine. So basically, it would be a person who is not a Ukrainian citizen. The crime for which the person would be prosecuted was not committed on the territory of Ukraine. There is no national interest at stake, and the perpetrator doesn't even have to reside. That's a pure universal jurisdiction. And we can see now how extremely important this is in the context of Ukraine, and how states, including mine, I'm from Slovakia, we have universal jurisdiction, how it's important that we are able to prosecute the crimes that are currently being committed on the territory of Ukraine, even though we have absolutely no link whatsoever with the crime that we are able to prosecute. So this would again be something that would enable the cooperation with the ICC, would make it much more efficient, and also would when Ukraine would be able to step in also in terms of prosecuting citizens of other countries. Further, the new law removed a provision that made the law, the 2689, applicable to crimes committed prior to the adoption of the law. And now when we see the situation with the law not even being adopted yet, when Ukraine has no legislation to try crimes against humanity and most of war crimes, and the crimes would only be prosecutable, so the law would only apply for crimes committed after adoption. This would exclude all the crimes that had already been committed. So if there is no retrospective application, those crimes would again fall outside of the jurisdiction of Ukraine, and the ICC would have to step in. So this would, or then maybe the crimes would try to be worded in a different way. But again, this is against the principle of legal certainty, and also we cannot try a war crime as an ordinary crime. So again, it's a shortcoming of the law, and also from the perspective and principles of international criminal law as well. And on this note, it's also important and very relevant to mention that even Article 9 of the Constitution of Ukraine specifically reads that international treaties that are in force and they're agreed by the Parliament of Ukraine are part of the national legislation of Ukraine. And all these crimes that are being implemented through this, through the implementing legislation, so 2689, so crimes against humanity and war crimes that are missing in the codified version of the Criminal Code of Ukraine, that they are already included in international treaties that Ukraine has already ratified. So according to this Article 9 of the Constitution, they are already binding on Ukraine. So Ukraine would be able to apply them. So through ensuring this in the legislation, it will be just effectively codify the already existing principle that they are prosecutable anyway. However, I understand that without the retrospective application specifically mentioned in the law enforcement authorities would be very reluctant to do so. Of course, because it will be also a little bit confusing if the law says that these crimes are only prosecutable after entry into force of the legislation. And of course, this principle relating to the fact that if a specific act is being criminalized by either customary international law or by international law, and so it could serve as a source for the prosecution in the domestic jurisdiction, even if at the time of the commission, the domestic jurisdiction didn't criminalize it. I mean, this principle is established under the ICCPR, so International Covenant on Civil and Political Rights, and also European Convention on Human Rights. So this is something that is, according to us, unfortunate that has been excluded from the new version of the law. And then finally, the new law is also, let's say, rewording the crime of aggression to some degree. So crimes against the peace also is under Ukrainian criminal code, because the crime of aggression is a leadership crime. So those in the position of power are to be held to account. However, this new law makes it applicable also to ordinary soldiers. So again, it is not necessarily in line with the ICL and IHL, international humanitarian law. So these two, now I was speaking about more the complementarity, and also I will later mention once more why these provisions are of particular importance if they are effectively domesticated. I'll move now to the substantive part on cooperation, and there I will also explain a little bit of what the cooperation with the ICC entails, why it's important, but also I'll have a look at our the newly adopted law on cooperation by Ukraine. Was adopted on 3rd of May, which implements the provisions on cooperation with the ICC and compare it with let's say what we as in our experience as PGA identified as model law, which provisions are necessary, and as I will compare it with the Ukrainian law. So the obligation which is ensuring the obligation of states parties to cooperate with the ICC is ensuring in Part 9 of the Rome Statute. So it's twofold. One, it's Article 86. So which stipulates there is obligation for states party to cooperate fully with the ICC, and then the Article 88, which imposes the obligation for states parties to ensure that they have the relevant domestic laws implemented that enable this cooperation. So all the procedures available under their national law. And while this article speaks about states parties, Ukraine, by virtue of the submission of the two ad hoc declarations, 12.3, has basically been placed to a position of a state party. So all these obligations are applicable to Ukraine as if it were a state party to the ICC. If the state fails to cooperate, basically the ICC may make a finding to this effect and then refer the case to the Assembly of States Parties, the ASP, or in case if the situation which is under investigation has been referred by UN Security Council, the ICC can make a referral to UN Security Council, but this is not applicable in the context of Ukraine. Also, it's just the fact that Ukraine has adopted the law is definitely a great advancement, which facilitates the cooperation with the ICC, because, for instance, in general, there is less than half of the states parties that have done so. So less than states parties, we currently count around 58 out of 123 of the Rome Statute have effectively implemented the cooperation provisions with the ICC. So unfortunately. Just as a quick key dates or the recap, Ukraine signed the Rome Statute already back in January 2000, but it still hasn't ratified it. But what has been exceptional, because it's the only state that is not a party to the Rome Statute, and this was even before the ad hoc declarations, Ukraine has ratified the Agreement on Privileges and Immunities of the ICC. And this is a very important agreement to facilitate cooperation with the ICC, because it grants the ICC staff privileges and enables the court to execute its mandate and to perform its duties when on the territory of Ukraine. The two ad hoc declarations that accept the ICC jurisdiction were filed in 2014 and 15. However, they accepted the ICC jurisdiction retrospectively, so as of 21st November. Then the second one was 20 February onwards. So for the moment, the ICC has jurisdiction for the crimes committed on the territory of Ukraine as of 21st November 2013 onwards. To pave the way for the ratification, the Ukraine also made a constitutional amendment to Article 124, which recognized the jurisdiction of the ICC. It had a transitional period of 3 years and became effective as of July 2019. So as of then, Ukraine is able to legally, under its constitution, is able to ratify the Rome Statute. And then, while following the full-scale invasion by the Russian Federation on 24 February, the ICC opened its investigations on the 2nd of March in 2022, as we know, after a referral of the 43 states parties to the ICC, which has been for the first time of such in this scale. And 2 months later, Ukraine adopted a law on cooperation, which I will speak about in a bit. So why in general the concept of the cooperation with the ICC is derived from the fact that the ICC is fully dependent on states when it comes to executing its mandate and any procedural aspects, so collection of evidence or interviewing witnesses or requesting for arrest and then surrender, which I will also explain in a bit. It's because the ICC doesn't have its own police or any law enforcement structures, and also because it was established with a full agreement to the state's sovereignty. So all these procedural aspects are done with the agreement of the state. But for the state to be able to accept and to effectively implement and execute any request for assistance, it has to have in place relevant provisions in its domestic law, because it cannot self-execute them without such procedural laws. So all states have to change their procedural laws and permit national authorities to recognize and enforce requests and orders. It wouldn't be possible without having these provisions in place. Of course, there has been some states that have agreed on or signed a memorandum on cooperation. but it's a little bit more rushed procedure than having a proper legislation in the place. So it is first, of course, the first step is to have the necessary legislation, but then of course to have it effectively enforced. So the legislation has to be effective and has to comply with these requirements. So the way how it works when there is a need for cooperation, for any assistance, is that the ICC issues the request through a point of contact, which is designated by the state, and then it's being executed by domestic authorities. So this could be law enforcement authorities. So it's judicial authorities or police of Ukraine. But there are also some instances where the Office of the Prosecutor of the ICC, OTP, may also execute some of these procedural aspects on their own. So, for instance, with the approval of Ukraine, and this, for instance, is mostly relevant when it comes to interviewing witnesses. Having an effective legislation on cooperation is particularly important because it enables the cooperation legally. As I mentioned, without it, it would be against the Constitution, basically, and also it wouldn't be possible for the state and for the authorities to execute their requests. But also it provides a more clear and streamlined legal basis and guidelines on how to actually make the cooperation work. And this is extremely important when we are speaking about fighting impunity and holding perpetrators of international crimes to account. So any execution of requests for assistance has to be made in an expedited and really efficient way. Otherwise, I mean, there is a lot at stake. And having this an effective cooperation law enables the state to create a smooth and direct channel of communication. So there is no ambiguity who is dealing with the execution of the request for assistance. And this is important not only from the perspective of the ICC state cooperation, but also we've seen in some of our countries that it really enhanced the national capacity to cooperate also interstate. And this is very important because Ukraine is one of the supporting states of the Mutual Legal Assistance Treaty, which facilitates the cooperation between states on the international crimes. So these are also the crimes that are being implemented within the Rome Statute. And as I've mentioned, the reason why this is of high importance is that when there is a delay in execution of such requests for assistance or if there is this failure, this is not only the fact that the country could be referred to the ASP, Assembly of States Parties, or the court could make a finding. The thing is that what's at stake is that we're speaking about atrocities and the perpetrators that sometimes are high ranking. So they could flee the territory of a state because the state has failed to accelerate the implementation and the execution of the request. So by the time that the state is able to execute the request, the suspect may be gone and the opportunity and the momentum is gone. And this, of course, not only reduces the court's efficiency and increases its cost, jeopardizes its existing mandate, but also it really leaves the victims of these crimes without any justice, and it takes away the whole effort to fight impunity and hold these perpetrators to account. And there is also an article of the Vienna Convention on Law of Treaties, according to which a party may not invoke the provisions of its internal law as justification for its failure to perform a treaty. So basically, the state cannot argue that they've failed to have the necessary law in its implemented in its domestic legal framework, and use it as a justification for failing to perform the request, because still it would not be applicable. It's the obligation of the state to perform the duties of the treaty. And as I mentioned, Ukraine has the obligation to cooperate with the ICC by virtue of the two ad hoc declarations. The types of cooperation that there are, so first of all, it's not only ICC requesting cooperation from Ukraine, it's also the other way around. Also, it's Ukraine or any state that can request the ICC for assistance, for cooperation. And this stems from the principle of complementarity that I mentioned at the beginning, where the both bodies, so the domestic system and the ICC, work in synergy. So they complement each other. So it's always a priority for Ukraine to prosecute and the crimes and the perpetrators. So they can always request the ICC for any information or for the evidence that the ICC had already collected. And this is ensured in Article 626 on the request to the ICC in the law on cooperation, and it specifically states that the Central Authority of Ukraine may send requests for assistance to the ICC. The other way, or the second, and that is the part of the cooperation that I will speak about as of now, is the ICC requesting cooperation from Ukraine. So there are two main types of cooperation. So one is for arrest and surrender. So surrender is a delivery of the person to the ICC that had been arrested on the territory of Ukraine, let's say. And then other types of requests for assistance. So this is not an exhaustive list. The Rome Statute basically mentions some of these that you can see here. So it's, let's say, the production of requested documents or records, collection of evidence, executing searches and seizures, protection of victims and witnesses. But so it can be any type of cooperation, of any request for assistance, because as we see in the very last part, the last provision, it says also it can be any other type of assistance which is not prohibited by the law of the requested state, so Ukraine. I'll speak now about the difference between extradition and surrender, because this is something that indeed has been sometimes flagged by some of the states as potentially causing a confusion and problems with the execution of the requests. So the extradition and surrender are two different concepts. Extradition only relates to interstate relations. So it's a discretionary act whereby one state extradites a person as a suspect to the requesting state. And this is a very prolonged process. It entails several principles that have to be complied with. So for instance, the principle of reciprocity, which means that the state that is being requested kind of makes a promise that it would also reciprocate a similar act to the requesting state. Then there is a...
Dear colleagues and friends that watching us online,
I believe I may continue. Then also it may entail the dual criminality. So this means that the state reassures itself that the crime for which the perpetrator is being sought is criminal in both jurisdictions, so the requesting state and also the requested state. And of course, this takes a lot of time. This causes delays, and it really makes the whole process much more complicated, and again may entail significant delays. And of course, there are also some exceptions, which, for instance, go for the political offenses. So if the crime, if there is a possibility, or maybe there is a suspicion that the crime is of a political nature, then the state may refuse. Also, if there is a risk that the the alleged perpetrator, the sought person, would face death penalty. The requested state may refuse the request for extradition, and also there is a prohibition in many constitutions on the prohibition of extradition of nationals. So all of this makes the whole process of extradition long and particularly complicated from the efficiency perspective. So for this reason, states have created the concept of surrender, and this is based on the understanding that it is a treaty between the ICC and the states, and this whole process is much more streamlined. There is no applicability of principles of reciprocity or dual criminality. Reciprocity, because the ICC doesn't have any nationals on its own. Dual criminality, because as well, I mean, it's this is not what's being considered or assessed. However, this is exactly where, if the state, so let's say if Ukraine has implemented the Rome Statute provisions, so on war crimes, crimes against humanity, it would facilitate the process, because there will be no ambiguity about whether the conduct is being criminal also according to Ukraine. And of course, there are no fears about the charges being based on a political nature, and there is also no risk of the applicability of death penalty, because ICC doesn't apply the death penalty. And also, from the perspective of a state, surrendering makes a big difference about its participation in the subsequent procedures at the ICC, because once the extradition is done in a normal interstate relationship, the state that extradited its nationals or the nationals of the requesting state has no longer any say in the proceedings that follow. But this is not what's the case at the ICC, because the ICC actively involves the state in all further process at its proceedings. The state, so Ukraine, would be able to challenge the admissibility, and of course also could accept the sentenced person at the end. So in a nutshell, this is very important to understand the difference, because using the extradition provisions would lead to delays, which would be again detrimental. And when I was speaking about the prohibition of extradition of nationals, is also in the Ukrainian Constitution, in Article 25. And when we see the Extradition Act of Canada, that I just used as an example, it specifically mentions that a surrender does not fall under this prohibition of extradition. So the grounds for refusal would not apply. And there has been also a judgment of the Constitutional Court of Ecuador, which specifically drew this difference between extradition and surrender, and specified why this is why the extradition but the prohibition of extradition of nationals would not be applicable under the surrender principle and the concept of the surrender. And it specifically says that the surrender cannot be assimilated to the legal concept of extradition. Therefore, the prohibition of extradition of nationals does not count. So it's not applicable, and the surrender does not contradict the constitutional prohibition. Now, going specifically to the law that was adopted by Ukraine on 3rd of May. So it's also the law which amends the criminal procedural code of Ukraine on the cooperation with the ICC. So at the outset, there is a problematic provision, which is at the very beginning of the law, which is the note, and it limits the cooperation with the ICC only to those alleged perpetrators that carried out armed aggression against Ukraine, or were following the decisions or orders by Russian Federation. And Of course, this is problematic because the law has to be neutral and both parties to the conflict may fall under the jurisdiction of the ICC. So it is possible that the ICC would require any assistance in relation to perpetrators not falling under this category. And this would be very problematic because if Ukraine were to apply this provision, it would mean that the ICC is not able to cooperate with Ukraine when it comes to the request for assistance for the other perpetrators. As to the specific aspects of such a law on cooperation, I will speak about some points that we have identified with PGA as important in our model laws. So, and also I'll explain why they are important. So in general, as I already mentioned, the legislation should ensure that there are no obstacles in national law to request for assistance, for cooperation, and the laws that would recognize the validity of all requests of assistance. And so, for instance, as I mentioned, that sometimes it's also the office of the prosecutor that is able to execute some of the procedural aspects of cooperation, such as interviewing of witnesses. It's important that also the office of the prosecutor is being recognized by the law. And in the current legislation, there has been probably a mistake in the terminology, and it only relates to the prosecutor of the ICC. However, the prosecutor of the ICC, it's only the chief prosecutor, and it's not the person who goes to the territory to conduct the interviews with the witnesses. So according to this article, the OTP, the Office of the Prosecutor, would not be able to be recognized for the purpose of the execution of these procedural aspects. So this is also something that is under discussion, whether how to remedy this potential shortcoming. Another important provision is the designation of an appropriate channel for receiving requests, so points of contact. And for instance, this is something I already mentioned before. So this is how the ICC issues the request. They only have one channel of communication to expedite and make the process smooth. So in the context of Ukraine, they designated their Prosecutor General and Minister of Justice, and each has different responsibilities. So basically the Article 618 specifically, I mean, there is also a more detailed provision, and we can see that there is a distinction. The cooperation during investigation and trials is ensured by the Office of the Prosecutor General, and during the enforcement of sentences and other decisions by the ICC, it's the Ministry of Justice of Ukraine. Another important provision that has been implemented, which is done properly in the Ukrainian law, is provisions on arrest and surrender. So this is also something that I already was speaking about in length, what the surrender means. The one provision, though, which is not being implemented and included in the law on cooperation, which is of importance, is how Ukraine would deal with competing requests. So the request, it's when there is a request by the ICC for either arrest or surrender or for any other assistance, and by other state. So ideally, the request of the ICC should take precedence over requests, for instance, from extradition from a state, independent whether the state is a party or not. There is a there is an exception if there is an international agreement in case of a state which is not a party to the Rome Statute. So in our model law, this is a very simplified way, but we have detailed provisions where we specify if the request is made by the state party to the statute. So the competing request is made by the state that has ratified the Rome Statute, then the ICC has priority. So Ukraine should execute this request for assistance to the ICC. The same, it's applicable if it's a state which is not a party to the statute. However, if there is international obligation to let's say, if there is any international agreement to extradite, then the minister may decide. So Minister of Justice of Ukraine. And you can see that it has to take into consideration some of the factors, such as when the dates of requests arrived, the interest, the gravity, the nationality of the victims, and also basically any other factor. But this is a provision that is currently missing in the law on cooperation. Further of particular importance is to ensure that immunities under national laws will not prevent a person from being surrendered to the ICC when requested. And on the left, we see the current law in Ukraine, which, in case that there is a diplomatic immunity, specifies that Ukraine shall immediately inform the ICC and postpone the execution of requests. However, again, similarly to the provisions that I've already speaking about, in our model law, we've identified also through it is a model law that has been implemented by the Commonwealth countries and has been approved by Minister of Justice of Commonwealth countries, and we have afterwards been also updating it. But they have already established that there should be a difference between whether the immunities are of officials of the ICC state party or not. And this stems from the fact that the Rome Statute in its Article 27 specifically mentions that the official position of the alleged perpetrator does not constitute a bar to the prosecution. So it's understood that all states parties have consented to this principle. By the way, this has also been ensured by the International Court of Justice in the arrest warrant case, where the arrest warrants by the ICC constitute one of the exceptions to the customary rule of diplomatic immunities. However, if the official is not from a state party, then there could be included a provision that the minister could consult with the ICC. So this automatic non-applicability of immunities would only apply when it comes to immunities of officials of states parties to the ICC. Similarly, in our model law, we'd also have this provision that, as I mentioned, basically implements the Rome Statute principle that the official capacity is not a bar to arrest and surrender. And of course, this is extremely important in light of the fact that most crimes are being committed by the commanders. Let's say we speak about the government structure, those that are responsible finally in the chain of command, they would benefit under traditional national law from immunities. So this is very important because to make these provisions effective. Also, as I mentioned before, there are all other forms of cooperation that may be requested by the ICC, and the more inclusive the law on cooperation is, the better and more expedited the whole process is. And this is a little bit problematic because in the current law on Ukraine, it contains a general provision which only speaks about other forms of cooperation, other requests. So there is no specific procedure to be followed, and this could cause delays in the execution of such requests. So it would be ideal to have more exhaustive list of what forms of cooperation there may be required. Another important provision is that under domestic law, that there are only narrow reasons which are acceptable for the refusal to comply with a cooperation request. This is something which is done well in the law on cooperation by Ukraine, because it only relates to exception of national security. So this is understandable that this constitutes a legitimate ground for refusal, of course, following and in consultation or explanation. Another provision which is important, which is included in the law on cooperation, is ensuring the preservation of evidence. And this is also in the case where the request for cooperation has been postponed. And this is very important because that Ukraine is able to collect the evidence and preserve the evidence even when there are reasons for postponing the actual execution of the request for assistance. And of course, again, if there are any complications, it's always important to consult the ICC. Very important provision is on protection of victims and witnesses, which is included in the law on cooperation in a rather limited way. And it's only under the reason for the postponement. So it speaks about when upon the request, the Ukraine has to take measures to ensure the safety of victims or witnesses. We believe that it should be a little bit more detailed and also include protection measures, such as, for instance, the conduct of the proceedings just between the parties, or with the exclusion of the public, and also measures to protect victims' identity. And of course, also relates to the families of witnesses and victims. Another very important provision relating to victims is effective reparations to victims. And this is something that we also highly recommend to be included in the legislation, because it's the state's responsibility to provide reparations to victims of the crimes. And also the ICC can order reparations to Ukraine. So there has to be a legislation that would effectively execute this request for reparation orders. And as you can see, there is an article so there are UN basic principles and guidelines on the right to remedy and reparation, and so which is applicable to atrocities. And while of course the responsibility to provide reparations stems, from the harm. So basically, the responsibility, the onus of the responsibility is placed on the state that has caused the harm. However, if the state which has caused the harm is unable or unwilling to meet the obligations, then the state, another state, so in this case would be Ukraine, that whose citizens have suffered the harm, it's the Ukraine's responsibility to establish national programs for reparations and other assistance to victims. So it's a twofold obligation to have in domestic legislation, and one is to effectively execute reparation orders by the ICC. And the other one is also a provision on reparations for the victims that would grant victims this right. And closely related with reparations is the provisions to identify, trace, and freeze or seize the proceeds, property, and assets of any fruits of crimes for the eventual forfeiture. And this is very important because exactly by seizing this property, or it can be used for reparations for victims, and also for legal aid in case that the defendant is not able to offer one. And while there is a reference to this in Ukrainian Criminal Procedural Code in Article 568 to search, arrest, and confiscation of assets, it refers to requests for international legal assistance. And in its definition of the procedural code, is specifically mentioned that the international legal assistance only relates to states' requests. So again, this provision would not be applicable when we speak about the request issue by the ICC. So it is highly recommended that a provision on this enforcement and eventual forfeiture were included in the law on cooperation of Ukraine. And then finally, this is a rather optional possibility that only enhances the cooperation with the ICC, And these are 4 so-called voluntary cooperation agreements, which, as you can see, basically relate to final release of persons that have been acquitted by the ICC. So sometimes they are not able to come back to the territory. And of course, we are now speaking about more broader cooperation for future between Ukraine and the ICC. And so let's say if there is a national who is not able to come back to the state of its nationality and has been released, so has been acquitted by the ICC, Ukraine could accept such person on the territory, on its territory. This is also applicable to interim release. So if the person is still not finally released, but there is an interim release for specific reasons, this is also there is a 3rd cooperation agreement on enforcement of sentences. So it's if the ICC finds someone guilty, that person can serve the sentence and in the prison of that state that accepted and signed this cooperation agreement. And then finally, it's the relocation of witnesses. So it's one of the protection measures where the witnesses that are in grave danger because of their cooperation with the ICC, because of having submitted a testimony, have they need to be relocated to another state and then cannot come back. So it's a witness protection program, and Ukraine would be accepting them. But again, these 4 are rather, there's an additional enhanced cooperation which facilitates the cooperation between Ukraine and ICC. Thank you very much. That's all on my behalf. I know we are running maybe a little bit short on time, but if possible, I would be very grateful for a little also comment from David, who is here with us, who is our Secretary General.
And thank you very much again to the Center for Civil Liberties for this wonderful opportunity, this full week of lectures. And let me only point one issue, and then if there are questions, of course, we'll be very, very happy to answer. And the issue is that it seems to me that these legislations that Frederika presented have suffered from some sort of fear that these laws may apply to Ukrainian armed forces. And these may be the same fear that has been suggesting, that has led to advisors to President Zelensky and in the past to President Poroshenko not to ratify the Rome Statute or to include the 3 years of transitional provision to make the amendment of Article 124 allowing Ukraine to ratify come into force only in 2019 when it was adopted by the Rada in 2016. When you read this note that Ukraine shall cooperate with the ICC only on the crimes deriving or connected with the aggression or committed by the aggressor, it doesn't make sense because the ICC doesn't even have the jurisdiction now on aggression unless the Rome Statute is amended, as PGA, by the way, proposes. And there is no reason to fear that the ICC will look into eventual possible crimes attributable to the responsibility of Ukrainian nationals for 2 reasons. Number 1, gravity. According to the criteria for the exercise of discretion by the prosecutor of the ICC, the prosecutor clearly goes to prosecute the gravest crimes. And if Ukrainian nationals may be committing some crimes, I would argue they are less grave because they may not be systematic. They are not like when there was the attack on Bucha, where you had a systematic or widespread attack against civilian houses, shelling of buildings, the killing of bystanders, the rape of women in houses. This has been a systematic and grave attack on the civilians, can be qualified as a war crime and as a crime against humanity. As I said 3 days ago, Mariupol's attack can even qualify as genocide. There is a very clear gravity scale. If Ukrainian soldiers or resistance or partisans might have committed some atrocities sporadically in some localities, I would argue the gravity threshold is not meant met, because under Article 8, paragraph 1 of the Rome Statute, the prosecutor shall give priority to those war crimes characterized by a certain level of large-scale commission or systematic perpetration. In a similar way, this is only orienting the discretion of the prosecutor, whereby this is the hard law in the definition of the crimes against humanity, whereby a crime against humanity can be prosecuted only if it's part of a widespread or systematic attack directed against any civilian population. I would argue that if there are some violations of international humanitarian law committed by Ukrainian soldiers, they would not meet this gravity threshold as of today. So who is advising President Poroshenko? Who has been advising President Poroshenko? Who is advising now President Zelensky? Why they're telling wrong things to him and they put in the legislation these type of clauses that make no sense? There is really a problem here. And as I said 3 days ago, the president has already rectified his course of action by deciding to remove from office some of the chief officers in charge of war crimes investigations, in charge of national security, in charge of a number of issues. Maybe these are the people who wrongly advised him. If I go back to a statement made by prosecutor Irina Verednikova, yes, she stated to the media in October 2021 that the reason why Ukraine did not ratify the Rome Statute, it was because there was opposition in the Rada. This is false. It's not true. The Rada never took a position on ratification of Rome Statute simply because the Rada can only discuss the ratification if the executive sends to the parliament, to the Rada, a proposal, a bill containing the decision whether or not to ratify the Rome Statute. How can you say the Rada is against when the Rada never discussed this in its history? So we have, of course, this is in the media. So there is something, Frederika's technical presentation was very clear. There are some shortfalls in the cooperation law. There are some shortfalls in the new law on complementarity. And there is this major problem of the non-ratification, which makes Ukraine a weaker party and partner of the ICC. Because as of today, Ukraine has all the obligations to cooperate and to work with the ICC, but has no right in the assembly of the state parties. So Ukraine is in a very difficult position that must comply with the obligations, but cannot sit in the state parties meetings and try to amend the statute, try to make its voice heard with equal dignity with the other state parties. So I would really leave this week of lectures with this major request for Ukrainian civil society organizations and activists and leaders in the legal field to go back to the office of the president and ask him once again, who's advising you on these matters? Let us talk to him or her, and let's open a frank conversation, because I think the information that they have been giving to you and the opinion that they may have had in their own mind is misinformed, is based on false data. And then we can move forward maybe with a process that would fully integrate and harmonize this type of law into the domestic legal order on one side, and then also to integrate and fully make Ukraine a party to the system in The Hague against impunity.
I'm grateful, Frederika, for her excellent analysis of Ukrainian relations with ICC, and I'm grateful for David for his opinion on the matter. And I would like to ask two questions that we received in the chat. First one is for Frederika. From your point of view, is it possible to consider the Donetsk Narod People Republic, so-called Donetsk People Republic inhabitants that are being conscripted to Russian Federation Army or to its proxy allies as unlawful combatants, and why? So this is a question about conflict classification. Such issue as a combatant status is relevant when we are speaking about situation of IAC, International Armed Conflict, or NIAC, non-international armed conflict. And from the start of hostilities in 2014, certain scholars and politicians argue that the nature of a conflict in eastern Ukraine is NIAC. But we all know, and we can be sure from 24 February 2022 that Russian direct military involvement and overall control over a separatist militia constitute an international armed conflict with the application of relevant legislation, Geneva Convention, additional protocol #1. And for me, and it is not a problem, but I would like to ask your opinion or a comment from David.
So I would also argue that it's an IAC, it's an international armed conflict. And from this perspective, the moment that these citizens are being conscripted officially in an army of another state, they are lawful combatants. I mean, there is, from my point of view, I would argue that they are as such lawful targets.
Yes, and Frederika, I think you cannot call anyone an unlawful combatant. There are two types of people at war. There are combatants or civilians. There are those in combat and those out of combat. There is no terrorist. There is maybe a combatant or a civilian who becomes a terrorist if he commits a terrorist attack, and then he would be adjudicated as a terrorist. This was George W. Bush's crazy theory after 9/11, that we had to fight a global war on terror against some unlawful combatant that didn't exist. They were criminals. They were committing crimes against humanity, but they were not unlawful combatants. The moment they are combating, they are combatants, full stop. You know, these theories are very, very dangerous because they're aimed at dehumanizing your enemy. The enemy is a human being with human rights like us. It's very dangerous. These theories, Roman, if people continues to repeat these theories, this confirms my opinion that certain people in Ukraine have been indoctrinated by those that during the George W. Bush and also the Donald Trump administrations, trying to rewrite international law by violating it, which led us to incentivize Mr. Vladimir Putin to think, I have impunity, I can do whatever I do. We have eroded the borders of international law. And I'm talking as a member of the Western community, as a citizen from a NATO country. We have made enormous mistakes. We need to learn from our mistakes. Because of the way we weakened ourselves, the Taliban are back in power in Afghanistan, and the war on terror has not been won because there are more extremist groups from Indonesia to Morocco now than in 2001. So they have failed totally, these people. Instead, these individuals like Osama bin Laden and so on, they should be tried before courts of law. And that's our civilization, that we bring to justice the Nazis after World War II, as we have to bring to justice Mr. Putin and all those who are committing a war of aggression and masterminding genocidal policies or crimes against humanity and committing them today against the Ukrainian civilians. Frederika wants to add something.
So I just want to mention that, of course, when it comes to unlawful combatants, what I believe maybe the question may have related to, the mercenaries are considered unlawful combatants, but it's basically just to remove the incentive of someone to join for financial benefits. And it's only that the IHL provisions would apply differently. So the unlawful combatant does not have this privilege of a soldier, does not fall under the bill that exactly. So, but it would be applicable for mercenaries, for instance. However, if they are integrated in the army, I would then argue that they become a lawful combatant.
From Ukrainian perspective, I believe that a person is speaking about situation when various young men in Eastern Ukraine are being taken away from the street, giving weapons without a training and put to the fighting without proper paperwork. So it is more likely that citizens of Eastern Ukraine and South Ukraine are involuntarily being drafted without proper paperwork done by the Russian side, but put in the so-called Donetsk People Republic militias involuntarily. So the problem here was that they are not accepted to Russian armed forces, but they fighting in the gray zone of proxy militias under umbrella of Russian illegal aggressive invasion of Ukraine. Yes.
These individuals are victims twice. They are suffering double victimization. You know why? Because number one, as long as they have a weapon and you see them on the war zone, you can kill them lawfully. So when they die, there's nothing to be done. They are lawful targets in an armed conflict, unfortunately. So that time they die and they are victim of the illegal aggression, but they're also victim of these forced conscription, which, by the way, if it's done on minor, is even a war crime as such. And it may also be construed as a serious violation of international humanitarian law, and their commanders may be held liable for such a violation. So, yeah, I think, but coming back to your original question, in our view, also in 2014, the conflict is international in nature, because the Lugansk and Donetsk Republic are receiving such a form of support which can qualify as direct effective control by the Russian Federation. Not just even overall control, direct effective control. So it would meet any standard for these entities to be puppets, like Transnistria, for example, or South Ossetia and Abkhazia of the Russian Federation. These are not really genuine separatist entities.
I just wanted to add to that what you are now speaking about the forced conscription. Think about child soldiers. It's also they are forcibly recruited because, of course, they cannot consent, but still they are lawful targets. But just to mention, when you mention that they are not integrated in the army, there is also another category, which is members of militia. And they are lawful combatants. So even if they are not integrated in armed forces, if they comply with 4 conditions, and this is, for instance, that they have they are commanded by a person, they have an emblem recognizable from a distance, let's say a uniform, they carry arms openly, and also they comply, I mean, that's an IHL provision, they comply with international humanitarian law provisions. So they can also be considered lawful combatants, even if they are part of militia, not officially integrated, providing these 4 conditions are fulfilled. Thank you.
Thank you, Frederika, for your clarification, and maybe one more question if you have time. It's regarding giving soldier to be trialed in Geneva, in Den Haag. If military enemy combatant, a war criminal, will fall into the hands of Ukraine, then first of all, our state will have to decide whether it will be prosecuted them independently or hand them over to the International Criminal Court, or ICC can take them away from us, from our national judiciary.
It's always the primary responsibility of the state with the jurisdiction, so Ukraine. It's only under principle of complementarity if Ukraine is not able to, because it doesn't have the necessary laws, or let's say the state is not at a stage where it's possible, and it can happen during the war, or if it's not able to genuinely do so. So also it's very important to say genuinely, because they cannot also try someone just to make it as a show trial, but it's always the Ukraine domestic jurisdiction that has priority. The ICC intervenes only if the domestic jurisdiction is not able or willing to do so genuinely.
Okay, understood.
Yes, and let me only add here that our understanding is that the cooperation between the 2 sides, Ukraine and the ICC, within the framework also of the joint investigative teams, so in cooperation with the Eurojust and a number of EU member states, I think it's such that there will not be really any problem there will be a decision at a certain point in time where the ICC may want to prosecute some mid-rank official in order to build the probative record to maybe then move to the highest level of responsibility. So it would be in the interest of the ICC not to have a foot soldier, but to have somebody in the mid of the chain of command who might have received orders from the top and could testify and maybe have a lenient penalty in The Hague, but so that there would be some very strong evidence that the top leadership issued the orders, or that the orders might have emanated from the National Council for Security or another body where you have the generals, the Minister of Defense, the President of the Russian Federation, and other high officials. So I think there will be a moment, probably very soon, where there will be an individual or two who will be maybe delivered by Ukraine to The Hague. I would say that this should happen also through sealed proceedings. So there is no need for the ICC to publicize these very preliminary proceedings. The understanding is that there is an ongoing war. Their understanding is that there may be problems with these individuals if they are detained. It's maybe better for them to think that they are not investigated at all, and suddenly, by surprise, there is a warrant of arrest and a very quick transfer. So it is, I think the Rome Statute gives the prosecutor office a number of possibilities to be effective. These possibilities must be explored and applied. And I think everything will be done in a very cooperative manner. So I don't expect really complementarity to be used as a challenge to the jurisdiction of the ICC.
David and Frederika, thank you for managing Q&A session. And on my behalf, Center of Civil Liberties, grateful for the Parliamentarians for Global Action for making this event possible. We're done with the questions, and I'm grateful for your time and your experience and your expertise. Bye.
Thank you for inviting us. Thank you. Bye-bye.